Your lawyer has asked you to watch this video in preparation for your upcoming deposition. It will help you understand what a deposition is all about, as well as give you some valuable tips and important information that you should know before you attend any deposition. First, what is a deposition? Simply, it's a formal question and answer proceeding where testimony is given under oath. Usually, a deposition is given in a much more informal setting than a courtroom. They are normally conducted in a law office or conference room, but they are just as important as if you were in a courtroom. You'll be placed under oath.
Please raise your right hand.
That means you should be completely honest. The information you provide in your deposition may be used in the actual trial if a trial becomes necessary. Therefore, it is extremely important that you, as the witness, be prepared and take the deposition seriously. During the course of this video, we'll show you what to expect as well as pointers on what to do and what not to do. Those participating in the deposition will include you, your lawyer, the court reporter, and the defense attorney for the opposing side. The defense attorney will be the one asking you questions. You may be referred to as the plaintiff, and the opposing party or parties are called the defendants. The court reporter is there to document the official record of your deposition word for word. The defense attorney's job is to get personal information about you and your account of the accident in order to evaluate your testimony. The most important thing you will learn from this tape is that you should always answer honestly. Don't reveal information that you haven't been asked about, but never jeopardize your case or risk being charged with perjury by not telling the truth. Your deposition is probably the most important element that you yourself will contribute to your case. A deposition is often used prior to a trial to negotiate a settlement with the opposing party. The testimony given is usually the best indicator of how well things would go during a trial and may provide some leverage for a settlement. Since most cases are settled out of court, you can see just how important your deposition can be. If you are asked about prior accidents or injuries, again, answer honestly, but don't exaggerate and don't give more information than just what is asked for. An opposing attorney can use a witness's testimony to show that the witness has given more than one account of the same event, therefore reducing that witness's credibility. Now we know how lawyers use depositions. Let's talk about the actual deposition itself. We'll start with what you will need to do before the deposition, how you should dress, how you should behave, and some important rules to follow. Once you are notified that you will need to appear at the deposition, with the permission of your lawyer, review any documents that will help to refresh your memory. The more you can remember about what happened, the more equipped you will be to answer questions accurately and honestly. It is likely that you will meet with your lawyer prior to the deposition to go over the case. Your lawyer will tell you which documents you need to bring and which documents to review. Do not provide or review any documents that your lawyer has not advised you to do. Some other ways that you may refresh your memory include talking to other witnesses, visiting the scene of the accident, and making notes about what happened. For instance, if you were in a car accident, it may help you to revisit where the accident took place. Try to remember all of the specifics of the day it occurred. Take pictures. Make notes of your surroundings. If possible, talk to the people who witnessed the accident. They may have seen something you didn't see. However, you need to refrain from discussing any matters with an opposing party. This is very important because you may unknowingly provide them with information they wouldn't have gotten otherwise.
Okay, thanks a lot. Bye.
Once you are notified of the time and place of your deposition, plan accordingly. Make sure you are available for that day and time. Make sure you have reliable transportation. If you need to arrange childcare, make sure you have adequate care in case the deposition goes longer than planned. Plan to arrive early. You may need to discuss last-minute items with your lawyer. Plus, if you're rushed, you are likely to be more nervous. Get plenty of rest the night before, and try to remain calm and relaxed. Avoid alcohol or medications that may alter your judgment or interfere with your ability to testify accurately. Dress comfortably, but professionally and appropriately. Prepare as if you're going on a job interview. It's important that you are seen as a credible witness, and good hygiene and personal grooming can go a long way. During the deposition, there are some important rules that you need to follow. Behave in a professional and courteous manner. Treat the opposing attorney with respect. Don't get angry and lose your temper. A common tactic of the opposing attorney will be to try and get you to overreact or get upset, especially if you are being asked a question of a personal matter. These types of questions are allowed. The defense attorney is evaluating what kind of witness you would be if a decision to go to trial is made. They may ask personal questions such as, where do you go to church? Or who is your best friend? You may feel that this is an invasion of a personal matter and totally unrelated to your case, but the defense attorney is asking these personal questions in order to help him with jury selection if the case actually goes to trial. Again, these types of questions are allowed. Don't be offended. Remain calm and avoid getting emotional or upset. Speak clearly and audibly so that the court reporter can understand everything you say. Ask for breaks if you need them. You are entitled to stop and take a break if you choose to do so. Now let's talk about some very important rules in depositions, what we'll call major rules. The first and most important rule has already been mentioned several times. That is, always answer the questions truthfully. In a deposition, you are placed under oath, and it is crucial that you answer each question honestly. Not doing so could put you in danger of being charged with perjury or lying under oath. If it is discovered that you are not telling the truth, not only will this reduce your credibility, but you could severely damage your case and reduce the odds of getting a judgment or successful settlement in your favor. Remember, yes, no, and I don't know are good answers. And don't reveal any information that has not been requested. Major rule number 2. Only answer the question that is asked of you. Provide the information that the defense attorney is inquiring about and stop right there. Don't volunteer any information by mistake that would not have been uncovered otherwise. Yes, no, and I don't know are good answers. This can become crucial when you are asked to remember what might be considered small but important details about the accident. If you are asked a question that you do not know the answer to, don't guess or feel pressured to elaborate. Simply answer, I don't know. Remember, it's okay to answer a question, yes or no or I don't know. And don't worry about giving an explanation of why. Major rule number 3. Allow the defense attorney to ask the full question before attempting to respond. This is important for several reasons. First, you want to allow yourself adequate time to think about the question and make sure you understand it. Second, by not allowing the defense attorney to finish the full question, you may testify inaccurately. Don't assume that you know what the attorney is going to ask. And third, you may accidentally volunteer information that may hurt your case by giving the opposing side information they were not even aware of. Don't volunteer any information that is not requested. Major rule number 4. If you don't understand a question, don't answer it. Don't guess about the meaning of a question. If you're not sure what the defense attorney means, say so. Ask for clarification. Make them rephrase it in a way you can understand. Don't be embarrassed. It's very important that you understand what is being asked of you in order to avoid giving an inaccurate answer. Let's take a moment to go over some of the types of questions that may be asked of you. First, the opposing attorney will ask questions of a personal matter. Your name, address, and occupation just to get started. This is done to establish your identity and your relationship to the accident involved. Questions of a more personal nature may be asked, such as, whom do you live with at the address given? What placed you in the position to be involved in the accident? Why were you there? These types of questions are allowed, but don't answer them from an emotional standpoint. Remain calm, don't get angry or upset, and simply answer the question truthfully. Remember, the defense attorney is evaluating your response. Show them just how confident you can be. You'll also be asked questions about the accident itself. For example, in your view, what happened? Once an overview has been established, you will probably be asked very detailed questions about what happened at specific times before, during, and after the accident. The defense attorney may make subtle accusations of wrongdoing on your part in order to elicit an outburst or get you to respond negatively, such as, did you contribute to the accident? They may question your motives for filing suit against their client or imply that you were the subject of some wrongdoing. Again, remain calm, listen carefully, take your time, and respond to the question, not the person. Finally, you'll probably be questioned about your damages. What kind of physical injuries have you received? What kind of pain do you experience? Have you ever suffered from a similar injury, or could your current pain have been caused by a prior accident or injury? The defense attorney will also be trying to assess what other damages you may have incurred, such as medical bills, lost wages, other out-of-pocket expenses, and overall general inconveniences. Be prepared to answer these types of questions about money and the problems you've experienced from your injuries. But it's important to remember, don't over-exaggerate and only answer the question being asked. Don't feel as though you have to explain your answer. With these kinds of questions available to the opposing attorney, there are several types of questions you'll want to watch out for during your deposition. One is what's called a compound question. This is where the lawyer lumps two questions together in an attempt to trap you into answering incorrectly. Let's use a car accident as our example. Let's say that you were hurt in the accident. You, as the plaintiff, have filed suit against the other driver, the defendant, who was negligent for running a stop sign. He was busy talking on his cell phone and never saw it. It was a rainy day, but the weather conditions had nothing to do with the carelessness of the defendant. The defense attorney might ask, on the day of the accident, would you agree that it was raining and that poor weather conditions made it difficult for you to see as you approached the stop sign? As you can see, there are two separate questions being asked. If you respond too quickly and answer yes to the fact that it was raining that day, you may have also agreed that your vision was impaired as you approached the stop sign. Take your time. Don't get in a rush to answer. This will give your lawyer time to insist that the question be restated. You too can avoid getting caught in this trap. Listen to the question carefully and ask the opposing lawyer to break the question down. Another type of question to watch for is an assuming question. This is when the question contains a false statement about your opinion or belief. It is very important in this case that you clarify that you do not agree with the assumption before answering the question, and correct them if they have made an incorrect statement. For example, the opposing attorney may ask a question like, as you noticed my client slowing down as he approached the stop sign, and you knew that the poor weather conditions may have had an effect, what happened next? With this question, if you're too quick to explain what happened, it can be assumed that you agree that the defendant slowed down before he came to the stop sign and the weather may have been partially to blame. You could simply respond by saying you never saw the defendant slow down before he ran the stop sign, and I cannot agree that the weather caused the accident. Listen carefully. If you notice that the question contains false statements, say so. Next, watch out for what is called a summary question. These are often confusing since they tend to be very complex. The opposing attorney will try to summarize your entire testimony into one sentence. When the defense attorney begins their question with, "Let me make sure I understand," chances are they are about to ask a summary question. Again, listen carefully, because if you agree with their summation, you may be changing the testimony you've given previously by agreeing to something totally different. Finally, be aware of argumentative questions. This is simply where the opposing attorney attempts to get you to lose your temper and become flustered. This applies especially to questions of a personal nature that you may find offensive. Remain calm and don't allow yourself to get angry. Address the question, not the questioner. Keep in mind that the attorney wants you to get upset and lose your temper. And remember, take your time. That will allow your lawyer to help better protect your interests. Because your testimony can be very important to your case, let's take a moment to recap what you need to remember about the deposition you are about to give. Before your deposition, review any documents that will help to refresh your memory with the permission of your lawyer. Ask your lawyer any questions you might have beforehand. If possible, revisit the scene of the accident, make notes about what happened, and try to remember all the specifics of the day it occurred. Remember to refrain from discussing any matters with a party of the opposite side. Plan accordingly for reliable transportation and child care if needed. Plan to arrive early at the location for your deposition. Get plenty of rest the night before, and try to remain calm and relaxed. Avoid alcohol or medications that might alter your judgment or interfere with your ability to testify accurately. Dress comfortably, but professionally and appropriately. During your deposition, behave in a professional, courteous, and calm manner. Treat the opposing attorney with respect. Don't get angry and lose your temper. Remain calm at all times and avoid getting emotional or upset. Speak clearly and audibly so the court reporter can understand everything that you say. Ask for breaks if you need them. You are entitled to stop and take a break if you choose to do so. Answer the questions honestly and accurately. And finally, remember our 4 major rules of depositions. First, answer the questions truthfully. Second, only answer the question that is asked of you. Third, allow the opposing attorney to ask the full question before attempting to respond. And fourth, if you don't understand a question, don't answer it. Now you know more about depositions and what you can expect. Your lawyer can answer any questions you might have. Don't be intimidated about asking your lawyer to explain or clarify any of the material we've covered. Remember, stay calm, be relaxed, be honest and truthful, and only answer the questions asked. With the information you've learned today, and with the help of a good lawyer on your side, you are better prepared for your deposition. Good luck, and we thank you for watching.